Well, thank you, Roger. This is a great treat for both of us. So it was just about a year ago that David asked me if I would consider offering an endorsement, otherwise known as a blurb, for the memoir that he was writing. And of course, when a friend asks you to do that, your heart sinks because, like, what if I don't like it? But so he sent me the first few pages, and I thought, oh my God, this is a wonderful book. And my role here, my very modest role here, is really to be the vehicle for David to tell us some things about his amazing life. So the title of the book, as you know, is Vision, and the epigraph kind of tells the story. It's the definitions of the word vision from the Merriam-Webster Dictionary. Vision, 1A, the act or power of seeing. 2B, a thought, concept, or object formed by the imagination. So David is going to read the first few paragraphs from the book, and it will give you the flavor of what his story encompasses. David, over to you.
Thank you. Before I read it, Linda, I just want to say what an enormous privilege this is for me. Linda Greenhouse has been this nation's translator of the Supreme Court for our people. It's a critical role which is now more important than ever, and it's just such a treat for me to have Linda read and discuss my book with me. So thank you, Linda.
Okay.
I've lived a rich and varied life. As a civil rights lawyer, as a federal judge, as a husband of 60 years, as a father of 4, as a grandfather of 8, and now as a great-grandfather. I've spent my professional career in the pursuit of justice, and I could have written a memoir entirely about that pursuit. But unlike most lawyers and judges, I've been blind for over half my life due to a rare inherited disease called retinitis pigmentosa. Throughout my 30 years on the nation's second highest court, the United States Court of Appeals for the District of Columbia Circuit, I could neither read a word of the thousands of legal briefs submitted to my court, nor see the faces of the hundreds of lawyers who argued before me. A blind judge sounds like a cliche, I know, like the Statue of Liberty, wearing a blindfold and holding a scale. But it's no cliche to me. I can't see, but I can listen closely. I didn't need to see the lawyers to hear their arguments, and I absorbed all the written materials by having them read to me, or later by using digital audio devices. For decades, I fooled myself into thinking my blindness was irrelevant to my work and my worth. Only now in my 80s, and in writing this memoir, have I finally come to accept my blindness as an essential part of who I am. This memoir is about my life in the law and my journey into blindness. It's also about the Supreme Court and my great concerns about the state of the judiciary. One more paragraph I want to read, which brings these two threads together. The two threads of this memoir have inverse trajectories. When I was coming of age, I was inspired by the role that lawyers and courts were playing in enforcing the guarantees of our great Constitution. But I was unwilling and unable to deal with my declining vision. Now, a half century later, I've made peace with my blindness, but I'm concerned about the Supreme Court's apparent disregard of the principles of judicial restraint that distinguish the unelected judiciary from the two elected branches of government, and about what that might mean for our planet and our democracy. Braided together, those two threads are my story.
And you see what I mean.
Thank you.
Okay. So, jumping into the meat of this, you talk about learning how to be a judge after many years of law practice when President Clinton put you on the D.C. Circuit. And now you're learning something else. I want to talk about that a bit. You've learned to be much more forthright than a sitting judge could ever be about the Supreme Court, about your concerns that you just expressed. So what was that like? I mean, has it been liberating? Is it one reason that you retired? I should mention, before David fully retired last year from the court, so he's now a free private citizen, you were for what, a year or two, a senior judge?
Yeah, year and a half.
Right. A year and a half, which means his departure from full-time status created a vacancy that President Biden could fill. But you were still under the constraints of being a sitting
Yes.
federal judge, and now you're not. So what has that transition been like, felt like? How did you process that?
Well, it's a good question, and it's not something I had actually, Linda, intended to do. When I started the book, I thought I would just write a memoir. I would tell my story. I really didn't understand at that point what writing a memoir really involved and how deeply it required you, if you were going to write a good memoir, to probe deeply into many things, including both my loss of vision and the courts. And the 3 years I worked on this book, my concerns about the Supreme Court have been growing for years. You know that. You and I have talked about it endlessly.
So some of your favorite opinions
Yes,
were the ones that got reversed.
Exactly, right. And so my concerns have been growing for years. But as I worked on this book and had the leisure, the ability to reread not just my opinions, but to go back and read the decisions of the Supreme Court, I became even more concerned. And I gained in that process a deeper, at least I thought, a deeper understanding of what was going wrong here. And I became more comfortable in speaking candidly about it. So it was an evolutionary process. It is actually a result of writing the memoir. I didn't retire to write a criticism of the Supreme Court. That was not my goal. In fact, my goal really was to write a book about both blindness and judging. But as I wrote, I became more comfortable with it and decided in the end to retire for a lot of reasons, only one of which was this book.
Although you say, I'll quote you, frankly, I was tired of having my work reviewed by a Supreme Court that seemed to hold in such low regard the principles to which I've dedicated my life. It had become, quote, an institution I barely recognized. And you can track that through. So to back up,
Yeah.
David was a civil rights lawyer, big time, interspersed with private practice, but really melding the two together. You were a founder of the Lawyers Committee for Civil Rights, right? First in
Yes.
Chicago and then the national,
Yes.
right? Mm-hmm. So talk a bit about that. We can kind of start with your professional trajectory. What drew you? University of Chicago law graduate, University of Chicago, not known for producing civil rights lawyers, you might say. So what was that?
So it goes back to my youth. I grew up in Silver Spring, Maryland. My father was a physicist, and when I went to college to the University of Michigan in 1960, my plan was to be a scientist. But I like to say I was captured by the 1960s. It was the height of the civil rights movement. I was fascinated with what was going on in the South, with the freedom rides, the sit-ins. I was totally enthralled with what the Justice Department was doing in the South and the Southern judges. And I was fortunate as a college student to have summer jobs during the Kennedy administration, which from the president on down hammered home the importance of public service. And so after just a couple years as a science major, I switched to political science. I wanted to be a civil rights lawyer. And so I went to law school. And fortunately for me, after I graduated from Chicago and practiced law for a few years, the Lawyers Committee for Civil Rights Under Law, which President Kennedy had actually called on to be created, opened up an office in Chicago. And I got that job, and that began my 30 years as a civil rights lawyer.
And you traveled in the South. I mean, you handled major litigation.
I did,
And,
yes.
And one of the cases that you write about that was the progenitor for one of the major civil rights precedents was really quite a story in the book. You want to talk about
Sure,
that?
yes.
Yeah, the Port Gibson case.
Yes, it's in a chapter called Too Beautiful to Burn. And it's the story of the consequences of a boycott. And so in the 60s, the NAACP organized statewide boycotts in Mississippi of white merchants because they wouldn't hire black people. And the merchants retaliated by filing a state antitrust suit against the NAACP and 150 boycotters in a little town called Port Gibson, Mississippi. When Ulysses Grant took Vicksburg and headed east to Jackson, his army marched through Port Gibson, and Grant issued an order to his troops that this town is too beautiful to burn, and they didn't. And the phrase "too beautiful to burn" is on all the lapels of the police and the firefighters. And so the chapter is called "Too Beautiful to Burn." To make a long story short, the merchants filed this civil rights act, this antitrust action, and they won in a state chancery court. They won $1 million judgment against the NAACP, which it could not afford. The NAACP would have gone bankrupt. The press reported the nation's oldest civil rights group on the verge of bankruptcy. Problem under Mississippi law is that you can't appeal a judgment without either paying or posting a bond of 125% of the judgment, which the NAACP couldn't afford. So it was unable to appeal. I represented the NAACP and went into a federal court in northern Mississippi before one of these great southern judges, and we argued that under Mississippi law, the NAACP's inability to appeal denied it its First Amendment rights and its right to access to courts. We won. We won a temporary restraining order, preliminary injunction. It allowed the NAACP to appeal to the Mississippi Supreme Court, where we lost unanimously, as we expected to. 5 years later, it resulted in a major win in the Supreme Court, NAACP v. Claiborne Hardware, a ringing endorsement of the fact that economic boycotts of this kind are protected by the First Amendment, and that decision protects boycotts of this kind today. I tell the story because, and I go back to my beginnings, I wanted to be a civil rights lawyer, and I was so impressed with these lawyers who went to the South and argued these cases before these great judges. And here I was, 20 years later, still relatively young, arguing a case like this on behalf of the NAACP in a federal court in Mississippi. It was in many ways it was a professional thrill of my life as a litigating lawyer.
You write in the book that the lesson you would like young lawyers to draw from your own biography is the need to find a mission and attach yourself to it, a professional mission.
Yeah.
And you write, because this was, your Port Gibson experience was at the time when your blindness was becoming hard to ignore.
Yes.
And so you write, as my vision clouded, the path I wanted to pursue was only becoming clearer. And you tell a number of anecdotes about your efforts to kind of fool people into thinking that you did not have a vision problem.
Yes.
Some of which are extremely poignant. Do you want to tell us some of those?
I'd be happy to. So I was diagnosed with this retinitis pigmentosa when I was 15. But at that point, I still was functioning like a sighted person, Linda. I couldn't see at night very well, and I had growing peripheral problems, but I was functioning pretty much like a sighted person. And when I was diagnosed at the National Institutes of Health, I was 15, I didn't go home and say to my friends, hey, guys, I have this eye disease. I hid it. I didn't tell anybody about it. I didn't want to be different from my friends. I was a little embarrassed by having this. And as I went off to college and law school and developed this mission to be a civil rights lawyer, I worried that my visual disability would adversely affect my professional life. And even in my mid-30s, when the RP deteriorated rapidly, and I began using readers and ultimately using a mobility cane, most of the people here know me from all those years as using a cane. Even then, I never talked about being blind. To put it simply, it wasn't me. I say in the book, I write in the book that when I went on the DC circuit, I wanted to be known as a judge, not a blind judge, but a judge who happened to be blind. And that's a big difference to me. Because I carried this reluctance to deal with blindness into my years on the court, I was determined to spend my tenure on the court to demonstrate that a judge, at least this judge, could function as a good federal judge even without sight. And so that's the story. And I tell all the stories in the book, many of them. You called them poignant, about the ways in which I hid my blindness or my declining sight when I was young, and the way I tried to make it unimportant as I grew older. Those stories appear throughout the book. Some of them are funny, some of them Linda called poignant. As I look back at them, some of them are a little sad.
Well, I'll tell one of them that struck me as poignant, which is when you traveled alone and were navigating your way through an airport, and you needed to use a phone. No, they didn't have cell phones. A phone to find a public telephone. You would be guided by the voices of people. Right. And the kind of voice that one uses when you're talking on the phone. Yeah. And if you heard those voices, you figured that's where the phone must be.
Yes. Right? Not until you asked me the question did it occur to me, I could never have done that in the world of cell phones, because the pay phones were all in one place. So as I'm walking down the concourse, you know what telephone talk sounds like, right? You can hear it. And I knew there were telephones there.
But of course, if had you had a cell phone, you wouldn't have needed to find a wall phone.
Well, that's a good point. Excellent point.
Right. But no, really, we've known each other a long time, although I never knew you before you were blind. But I knew you before you were a judge.
Yeah.
And we never talked about it.
No.
But when we used to run into each other in the DC Metro, many, many mornings, we seemed to be on the same time, and we would sit, stand together in the subway car, and you would be telling me things that you had read that morning in the New York Times, and I was always just kind of abashed because although I did try to read the Times every day, it was sometimes not until late at night that I got to it. But you had in those early adaptation days, much harder than now. The Times had an audio version that you could log into, and you must have gotten up at 4 o'clock in the morning because you always knew everything that was in that morning's paper. It was.
I love the New York Times, Linda. So.
Yeah. So.
Yeah.
But back to your civil rights career. So you go on the D.C. Circuit in the Clinton administration. Clinton, of course, succeeded by George W. Bush, and the legal environment started changing, and you got the assignment in one of the early Section 5 Voting Rights Act cases, the Texas case, the case known as Namudno. Tell us a bit about that, because what is very interesting about that case is, and you point this out kind of gently in the book, but I wonder if you think less gently about it now, that the liberal judges on the court, none of whom were blind, could not see around the corner to what John Roberts was doing in that case. So let's talk about the voting rights.
So maybe just a quick background for everybody. So the Voting Rights Act of 1965, probably the most effective piece of civil rights legislation ever passed, did many things, but most importantly, it required certain southern states with a history of racial discrimination in voting to submit any change they made in their voting procedures to the Justice Department and prove it wasn't discriminatory. Dramatically successful. They did it under the 15th Amendment, which prohibits discrimination based on voting, and especially Section 2, which is only 12 words, and it gives Congress the authority to enforce the provisions of the amendment through, quote, appropriate legislation. Maybe in my view, Linda, I think those are some of the 12 most important words in the Constitution, because they were added right after the Civil War, and they dramatically changed the relationship between the federal government and the states. They shifted to Congress all the power it needed to rid the country of discrimination based on voting. And 4 times, the Supreme Court sustained the Voting Rights Act under Section 2. The Supreme Court said Section 2 gave Congress all the authority it needed to identify certain states and require them to submit their changes to the Justice Department. My count is 28 or 29 justices, some appointed by by Democrats, some by Republicans. They all agreed. I think there were only 6 or 7 dissents. Flash forward 50 years, Congress extends it again. It comes before the Roberts Court. And the argument, the challenge this, and I was assigned to the case randomly, but as a district judge, we could talk about those details later. The point is, I had before me as a member of the court the constitutionality of this. I thought this statute was clearly constitutional. For me, as a appeals court judge, Supreme Court precedent had made it clear, and the 15th Amendment was clear. The case was not difficult. And I wrote the opinion ruling that this was constitutional. Well, when I got to the Supreme Court, by the way, the first person I called after I wrote this to find out whether it might go to the Supreme Court was Linda Greenhouse. I didn't ask my colleagues or my law clerks. I quickly called Linda to find out, hey, is this going to go to the court or not? Remember?
Yeah, I do. Not too many judges ever did that.
Right. So the Supreme Court ducked the constitutional question.
On the first round.
Yeah, in this first case, it ducked it. It said, this case was brought by a voting district in Texas, and it ruled that that particular voting district could, what is called bail out, from the Voting Rights Act. So it essentially eliminated the constitutional issue. But the court, in an opinion by the Chief Justice, and this was unanimous, went on to warn Congress that this was unconstitutional. It said it raised serious doubts about the ability of Congress to treat the states differently. It invoked a doctrine called equal sovereignty. It's not in the Constitution. You won't find it there. And the Supreme Court itself had made very clear that equal sovereignty applied only to the admission of the states to the Union. Yet the court invoked this principle to warn Congress that this might be unconstitutional. That was the end of that case. What did Congress do in the next 5 years? Nothing. Here was the most important civil rights law in the books. Congress had been warned by the Supreme Court that at least The court thought it was unconstitutional. They did nothing. And then, should I just go on to Shelby County? Yeah. Okay. So then it comes back to the court, back to my court, and I am again randomly assigned to this. And I again write the opinion sustaining the constitutionality of the act. My job as an appeals court judge was to apply existing law, not to predict where the Supreme Court might go. Obviously, it had signaled where it was going, but my job was to look at the court's precedent, the 15th Amendment, and apply existing law. If the court wanted to change it, it had to change it itself. And then it comes back to the Supreme Court, and this time, 5-4, the Supreme Court declares it unconstitutional. Now, and it invokes this equal sovereignty principle. To me, this case is a perfect example of what's wrong with this Supreme Court and how it has departed from basic principles of judging. There's no debate here about the underlying constitutional right like there is, say, in Dobbs. The 15th Amendment is crystal clear. Congress has this authority. But yet the court invoked this court-made principle, applied it to a situation where it doesn't apply. And if you read the Shelby County opinion and compare it to the court's earlier decisions sustaining the law, in the earlier decisions, the court writes about the serious racial discrimination in voting in the South, the harm that discrimination does, the threat to our democracy. Shelby County, it's all about federalism. It's about state autonomy. The court doesn't mention the 15th Amendment until the end of its opinion. It's as if the 15th Amendment had not been added to the Constitution at all, and that what the court was applying was pre-existing constitutional law. It was worried not about the victims of racial discrimination in voting, but about the autonomy of the states, about the fact that the states had to come, as one of my colleagues said, hat in hand to the Justice Department to change their laws. If any of these judges were originalists, they would have come out the other way. This is the easiest case I can imagine for an originalist to decide. All you have to do is apply the 15th Amendment, and you're done. But yet this court, presumably at least thought to be originalists.
Of course, looking back, looking at the pair of cases, the first one that was really a shot across the bow.
Right.
And then the second one that did the deed.
Right.
The first one, I think the vote was 8-1.
8-1.
All the liberals signed on.
Yeah.
And so the question is, what were they missing?
Well, we don't know for sure. I think what happened. First of all, the court. We know this. The court had two conferences. That's very unusual. They took a vote, and it was apparently 5-4. And then there were more conversations, and the justices apparently got together again and agreed on a deal, which is that they would not declare the law unconstitutional, but that they would warn Congress. Well, I don't think that, and I don't know this for sure, Linda, but maybe historians will get into the record and find out. I don't know whether the liberals agreed not to write separately to point out what the court was doing, but they didn't. And they sat there and allowed the Chief Justice and the majority of the court to invoke this court-made principle that and eviscerate the 15th Amendment. And, maybe they thought Congress would respond. Maybe they thought, with this warning, obviously Congress will fix the problem. I mean, little did they know how, dysfunctional our Congress really is. And so then it comes back and the court just invokes the principles of Northwest Austin and declares Shelby County, the voting rights unconstitutional, and the four liberals who had been on the court were just left to write a dissent, a powerful dissent, I have to say, but one I think they never anticipated they'd have to write. Do you think that's right?
I think so.
Yeah.
And really the reason that story is so exemplary is that it goes to the heart of your idea of what it means to be a judge.
Right.
And when you talk about learning how to be a judge,
yeah.
You talk about your role models, and the two that you name were Judge Learned Hand, who never made it to the Supreme Court, but a highly distinguished appellate judge, and Justice Lewis Powell.
Yeah.
Now, that's a kind of strange role model, Lewis Powell, because he was a very conservative, blue-blooded Southerner who one would not have thought a Democratic appointee would have chosen, named as a role model. Yeah. But you write in the book that the favorite description that anybody ever wrote about you as a judge was a political progressive and a judicial conservative. So you were widely considered to be one of the liberal judges.
Yeah.
You always, in conversation, kind of resisted the a label, not the liberal label, but any label. But talk a bit about how to balance your progressive druthers and your very strong sense of the judicial role.
Yeah. So just a little one factoid here about the two judges that Linda mentioned. During the summer of '94, when I was waiting for Senate confirmation, I devoured as many judicial biographies as I could. I figured this is a good way to figure out what my job is. and the two that really struck me were Jerry Gunther's fabulous biography of Learned Hand, which, if you ever want to read a biography of a judge, that's the one to read. It's really good, after you read my book. And a really good biography of Justice Powell. Those two books, they resonated with me because in both books, the authors emphasized the emphasis in these two judges' judicial lives of notions of judicial restraint, of using the awesome power of the courts only when absolutely necessary to protect constitutional individual rights, and things like faithfulness to the Constitution, following precedent, respecting the narrow jurisdiction of courts. I could go on and on. These are principles that these two judges, well, one judge and one justice, used throughout their career. And that, that's what I learned in law school also, Linda. That made sense to me, and most important, those were the tools that I was able to use to separate my own personal views about cases from the law I was supposed to apply. They were limiting these principles of judicial restraint, but they were also enormously reassuring because they left me feeling, all right, I've been able to separate my personal views, and I can prove it because I've written opinions which produce results that are different than I would have done if I had been a member of the Senate. And that's what judging is. And that's what's absent in this Supreme Court.
So our time is fleeting, and I want to save time for questions, but there's one last thing I'll ask you about that struck me. You talk about two cases that, in retrospect, you're sorry you didn't recuse yourself from because of your blindness.
Yeah.
And both of these cases had to do with the visual.
Yeah, right.
With objects that were described to you, that you felt you had an idea of. But to talk about those, because for a judge after the fact to say, I should have recused, is kind of a big deal. So.
Yes. So actually, there are three cases.
Three?
Pardon me? Yeah. One case, which Linda didn't ask me about, and I won't talk about unless you all want me to, is a case where I did recuse myself. And by the way, I applied what I describe in the book as the Tatel 5-minute rule. And the Tatel 5-minute rule is very simple. If I had to think about recusal for more than 5 minutes, I recuse myself. And the reason for that is that it leaned towards recusal. In other words, put the benefit of the doubt in favor of the integrity and impartiality of the courts. The two cases Linda's talking about, remember I said before how writing a memoir makes you think deeply? Had I not written this book, I don't think I would have been saying I should have recused myself in those cases, but I've thought about them a lot. They both involved, one involved currency, dollars and dollars, paper currency, and the other involved architectural drawings. And you needed to be able to know exactly what the currency looked like. One involved counterfeiting issues, and the architectural was a copyright case. One architect claimed another had stolen her designs for an embassy. And so you needed to be able to see them. Well, the way I prepared for them is, actually in the currency case, my then, 18, 19-year-old daughter happened to be in the courthouse, and she spent a good couple of hours with me going through these currencies and explaining as carefully as she could the difference between the so-called counterfeit ones and the real ones. And I used my fingers to do it. And then on the copyright one, my clerk did the same thing. And we spent hours trying to understand. And I went ahead and I sat on both cases. I wrote the opinion in the architectural drawings case. It was a long opinion. It had pictures attached. And the currency case was what we call per curiam. There wasn't a written opinion. We wrote it as a group. But so, the more I've thought about that, the more I've thought that what worries me retrospectively, and by the way, I did some tests about this while I was writing the book. I worried that my daughter and my law clerk, who were extremely conscientious about this, were in their description of what they saw, reflecting how they thought the case should be decided. In other words, they knew what the issue was. And I worried that, unlike a copy machine where I would get exactly what was there, I was getting a description that might be subtly influenced by whether they thought it was copyright or whether they thought whether they thought it was a counterfeit. And as I look back on it, I think, I'm the judge, not them. And I had to make the decision. And I think, looking back on it, that I should have allowed another judge to sit on the case for that reason. And there's a second factor, which is related in the other case where I did recuse myself, which is the public's perception. The integrity of our courts, the ability of the courts to perform their mission depends entirely on the public's confidence that the courts are impartial. And I worried in part, that the public might think, how can a blind judge make a copyright decision about this? In fact, I was totally offended. The New Yorker wrote a story about the first case, and the defendant, who was a performance artist, was quoted in the New Yorker as complaining that there was a blind judge on the panel, and he made some nasty remark about him even maybe having a guide dog, which I didn't. Anyway, I tell this because, recusals have been, the country's paid a lot of attention to recusals by judges, and
failure
to recuse, and I don't comment on any other judge in my book. My book is about the courts, not about justices. And people will have to read my book and decide from that what I think about what other judges have done. But to me, the most important thing for a federal judge is to ensure that that the public is confident, has no basis for questioning, or no reasonable basis for questioning the judge's impartiality. That's so fundamental to the operation of our courts. Federal judges are appointed for life. You can't vote against us if you don't like our decisions. And so the only reason the public respects the courts is that they think or hope the courts are applying objective law to the facts before them. And if the public thinks that that's not happening, the credibility of the courts can be severely hurt. And my own view, Linda, is that one of the reasons why the public respect for the courts is so low now is both because the courts have become so ideological and also because we've had all these questions about recusals and whether judges should recuse. Once there's a public question of whether a judge should recuse, we've lost the battle. The judge should never get in a position where the judge's failure to recuse becomes a public issue.
That's a good point to sort of end this part of our program on, very thought-provoking. And time for questions. And there's a microphone coming around. And okay, Frank Stewart.
Frank Stewart, New York. If you were empowered to make 3 amendments to the US Constitution, what would they be?
Let me just interject. Justice John Paul Stevens, when he retired, wrote a book with the 6 amendments that he would like to accomplish, like getting rid of the Second Amendment and so on. But over to you, David.
Well, Frank, I can tell you one that I would do. I talk about it in the book, and that is term limits for Supreme Court justices. I was always against them, but now I think they're a good idea. I only spend 3 sentences in the book on them because I don't think they're going to happen. I think Congress isn't going to do it as long as we have a filibuster. And even if it did it, I think the court would declare it unconstitutional, and I think the court might be right about that. But if you gave me this opportunity, if I could amend the Constitution, I would have 18-year term limits for Supreme Court justices. I think it would do a couple things. I think it would take the pressure off appointing the youngest possible judges, which is really not healthy for our institutions. It would give every president an opportunity to appoint justices, which would be good for the diversity of the court. And it would prevent people from staying too long and becoming too rigid in their thinking. That's one amendment. I could, if ask me tonight at drinks, I'll come up with 2 more.
Okay, we'll take another question. Up in the balcony.
Larry Einhorn, Indiana. 2 quick questions. You mentioned that it's a lifetime appointment, so they're not beholden to any political party. Do you really think that's true today? Because I don't. And second question is it harder to overturn precedent? Because it seems to be overturned pretty readily these days.
I think faithfulness to precedent is a really important element of our judicial system, and for lots of reasons. Let me just give you one example. When a court composed, say, of a majority of Democratic appointed judges follows a precedent written by a court with a majority of Republican judges, it sends a powerful signal to the public that something objective is going on here, that this is not a political institution. I mean, that's one reason. There's many more reasons. I mean, each constitutional decision of the Supreme Court is itself an interpretation of the Constitution. Now, of course, precedent can be overruled, and the court itself has articulated the standards for doing that. But it's difficult to overturn a precedent, and it should be. And since you asked about precedent, I dare you to read the Supreme Court's decision in Dobbs and explain to me why it overruled Roe v. Wade. And to me, this is about judging. An opinion of a court has to be persuasive. If it doesn't explain to you in rational terms, reasonable terms, what laws it's based on, if it can't do that, then you can legitimately suspect that something other than judging is going on here. And when I look at Dobbs, I don't see the reason for overruling Roe other than, as Justice Kagan said, that the personnel of the court has changed. You can read Brown by comparison, and you can see exactly why it overruled Plessy. So precedent is important. It has to be changed sometime. Brown's a perfect example. But it should be very difficult to change. And unfortunately, with this court, Linda's written about this. You've written a couple of very powerful columns about how quickly precedent falls under this court and how little respect it seems to have for the decisions of earlier courts.
Question over there, yeah.
Yes, Roger Smith, University of Pennsylvania.
You want to talk into the mic?
Roger Smith, University of Pennsylvania. Is it not Okay.
I want 1 minute.
Thank you both for a wonderful discussion and for your contributions to American constitutionalism. I want to ask the judge his thoughts about issues of disability rights. As you know, there is a controversy amongst disability advocates about whether priorities should go to resources for cure or whether, as a matter of civil rights, we should be adapting our institutions to accommodate participation by people with a wider range of abilities. So the question is, as someone who has performed so successfully in our institutions, do you see that as an important frontier of civil rights development, or do you have some reservations about going far in that direction?
I don't think those are in conflict. I vote for both. I think it's important to enforce our laws that prohibit discrimination on the basis of disability, and I think it's important to adapt our institutions to people with disabilities in reasonable ways. But I also think my book ends, the epilogue of the book. I talk a lot in the book about several disability cases, mainly to talk about the Supreme Court. But in the epilogue of the book, I talk about 3 neuroscientists who are actually restoring sight to blind people. And it's amazing what's happening. And I understand from my scientist friends who are working in this field that what we will see in the next decade in terms of preventing and curing many kinds of blindness will be breathtaking. But that's great. But it's not a substitute for enforcing the existing laws we have about disability discrimination and bringing people with disabilities into the mainstream. Many people have asked me why I wrote this book. My answer, having written it, is different than when I started to write it. And one of my answers now is I hope this book will demonstrate to people, I hope it'll be inspiring to everybody, but I hope to people, like people who make hiring decisions and say law firms or corporations, I hope they read this book. And that when next time they're looking at 3 applicants and one of them is blind or one of them is deaf or one of them's in a wheelchair, that they just make the decision based on the merits. And that they ensure their institution is capable of responding to the reasonable needs. I tell many of those stories in the book. I've been very fortunate in the extent to which the law firms and courts that I've worked for have accommodated my blindness. And had it not been for that, I wouldn't have succeeded. So I'm for both.
Okay, we have to stop. David.